The application moved by counsel for the petitioner wanted the Supreme Court to grant its leave of an order to be allowed to access the originals of the constituency presidential election results collation forms Form 9 for all constituencies in Ghana. It is also asking for original copies of the constituency presidential election results summary sheets Form 10 for all constituencies, the originals of the regional presidential election results collation forms Form 11 for all regions. Also, the originals of the regional presidential election results summary sheets Form 12 for all regions in Ghana, the original of the declaration of the presidential results Form 13, and the records of the alleged updates to the purported declaration of presidential election results on December 9, 2020 of the results of 4 constituencies in the Greater Accra region. Mr. Chachikata, moving the application, said the application was necessitated by the fact that a request for inspection of documents was filed on January 19, 2021. Mr. Chikata averred that figures in respect of the alleged update, including figures of total valid votes cast, are different from the declaration which was made on December 9, 2020. He added that total valid votes cast is 13,119,400, while the Electoral Commission stated 13,434,574 as total valid votes cast. Again, he argued that in their amended petition, the individual figures acquired by the 12 candidates sums up to 13,121,111, a figure which was adopted by the EC in their answer filed on January 9, 2021. Mr. Chachichikata told the court the conflicting figures makes the situation rather complicated, and in order to authenticate which of the figures is accurate, they must be allowed to inspect the original documents in the possession of the EC. Again, counsel for the petitioner explained that Article 1913 of the 1992 Constitution allows for a fair trial and within a reasonable time. Mr. Chikata, in his submission, noted that although a similar application was refused in the 2012-2013 election petition, it was because the petitioner then had produced before the court carbonized documents which they had certified as authentic and were confident about. He explained that in their case, they have no such documents and are only basing their misuse on the EC's documents, and so it was prudent that the court granted as requested. Counsel for the EC, Mr. Justine Amenuvo, in opposing the application, raised the matter of timeliness, asking why the petitioner was now making such a request 34 days after filing the petition and when trial is underway. He said the petitioner under Article 64(1) had 21 days from the day of declaration to file the petition and could have applied for the set documents, which he did not. Counsel for the second respondent, Mr. Akoto Ampao, argued that the petitioner, just like other candidates, are in possession of carbonized copies of all documents from the constituency, regional and national level, and therefore their application was misconceived and didn't warrant the demand. Mr. Ampao also averred that the application was an attempt by the petitioner to shift the burden of proof and persuasion on the first respondent, and that the petitioner needs to provide evidence to back their claims of the lack of transparency for which they demand inspection of the original documents. The court in their ruling said that the petitioner had not demonstrated to the court that they were not in possession of copies of the documents, and under Section 166 of the Evidence Act 1975, a carbonated paper of the document is equally admissible as the originals.